Yes, Mr.
Well, just three final points about the choice of methods in this case before I move on to look at some of the subsidiary points and the reasoning of the tribunal EAT. First of all, a point I hope I can make just briefly, but both the tribunals below and the respondents repeatedly make a point to the effect that average total pay is the only way of measuring actual pay differences. That, first of all, rests on the premise that what you have to measure is actual pay differences, and I've explained why that's wrong in principle. But secondly, even if that were right in principle, it's simply not true to say that average total pay measures actual pay differences. Conflating average and actual pay is a factual error. The reality is that average pay is a statistical tool in just the same way as the analysis of clustering, chi-squared, or average variable pay are all statistical tools. So it's a point that I could make ad nauseam by reference to lots of paragraphs in the EAT's judgment, lots of paragraphs in the ET's judgment, and lots of paragraphs in the respondent's skeleton. But can I leave you with that central point, that when you come back and you look at those, please be careful to note the number of occasions where there is a slippage from average to actual and treating the two as if they were the same thing. Second point is just to take you to the variable pay average statistics that we've put in our skeleton argument at paragraph 65, which is page 24 of bundle, page 20 of the internal numbering. So I make clear this table was not before the tribunal, it was produced within our skeleton argument for the AT, and this is what we had the scrap about. Before the tribunal, the farthest I took it was to, as I said, say to the judge, this is an example of why total average is wrong. Look at the pay range tables, and if you take subtract the minimum for the year from the two actual average figures and then compare them, then you would be doing a comparison of the variable bit. And I left it at that, having then said that's what you'd have to do if you were going to do averages, but I'm not relying on averages. So that's where we went with that. So I don't want to spend a huge amount of time on them, save to say that they do really underlie the point that in this case and on these facts, when you strip out the bit of pay that is not causally affected by the factor whose causal effects we are analysing, the differences are very significant in average pay. And even on the basis that I put it to the judge, it was incumbent on him, this may be important for one part of his analysis, it was incumbent on him to consider that explanation for why the small total average pay figures might seem not significant. And the last point I wanted to address before moving on is my Lord Justice Ryder's question as to whether you can ever look at both. And I think the answer we've got to through our exchanges this morning is yes, you can, because what you have to do in every case is start from the premise that what you need to measure is differential distribution, and then...
Is that the right way of putting it? Isn't disparate impact better?
I'm happy with disparate impact.
Differential distribution sounds as though you're assuming what you have to prove.
It might do, but disparate impact...
It's a refiner technique that actually isn't, as my Lord would alternatively
yes.
describe it, getting to the point.
Yes. So you start from the premise that what you have to measure is whether it is particularly women who suffer a disadvantage and not whether that disadvantage is particularly serious. And you then have to logically test whether in that case various different possible approaches or forms of analysis help you to test that point. And this is a point I made to both the ET and the EAT. It may be, and in fact it was the approach we adopted, that in most cases you can adopt a battery of different tests, because that will help them either reinforce each other or enable you to say, actually, these statistics aren't reliable because different tests produce different results. But what you have to do in relation to any test you adopt is you have to appreciate the logical consequences of that test. So in relation to average pay, what I would say is this: if you're going to look at average pay, you have to acknowledge and take account of the effect of including the non-variable bit of pay. And logically, that will mean that in most cases, including this case, taking average pay, certainly taking it by itself, is misleading and not a logical way of testing the proposition that you need to test. And if you're going to use averages at all, exactly as I put the case to the judge, you would have to take averages based on variable pay only, because that may logically test what it is that you need to analyse.
Which the judge would have been entirely appropriate, had he or she said, but that isn't the evidence you put in front of me. So what am I supposed to do?
He could have said that if that were the test, but that's not the evidence we relied on. We relied on the evidence of clustering. And the other point to make in relation to averages is, even with the distorting effect of the basic pay, it may still just about be relevant to look at them as the tail end of the consideration of the evidence, as it were. Bearing in mind what it is you have to measure. So you're not measuring, is this a significant difference in pay? You're measuring, is this supportive of there being a significant difference in the incidence of lower pay? And so...
Sorry to interrupt, but do you say that is not what the expert for the revenue did?
Yes. I can make that good shortly if I need to.
I just want to be absolutely clear.
That's not what the expert for the revenue did. And he said as much in answer to questions in cross-examination. And the way you may use it in that way, therefore, again, this was a point I made to both the judge, I think, and certainly to the EAT, is as a final backup test. Because even taking into account that distorting effect, what you will get if you have a differential distribution is you will get persistent lower average pay for women compared with men. It may just be a very small percentage difference, and what you have to understand is the reason for that percentage difference being very small is because of the effect of taking account of the bit below the variable amount. And we haven't yet been to the average...
So if you had tested it and there had been no difference in average pay, there would have had to be some head scratching.
Yes.
Logically, if you're right, there has to be a difference in average. Your point simply about its extent.
There does. Perhaps I'll take this point now. One of the points that's taken both by the judge and still by Mr. Linden and Ms. Moretto in their skeleton arguments, they say you could end up with a position where you have a differential distribution that favours men, but average pay favouring women. And we on our side have done some head scratching to try and think how that would be mathematically possible. And we can't come up with any scenario, let alone a realistic scenario, where mathematically you could have a differential distribution that favours men, but they come out with lower average pay. Perhaps
or women. Well, I mean, why put it that way around?
Sorry, a differential distribution.
Favouring men, but lower average pay for women.
Yeah, lower average pay for women. No, sorry,
Yeah.
higher average pay for women.
Yes.
So I'll save any further comment on that for reply. If Mr. Linden manages to come up with some hypothetical or realistic scenario where that might be possible. We haven't yet been to the mean pay statistics. They're at page 110 of the core bundle. And then over the page 111.
Hang on one second.
The grade 6. But what you do see, if you come to them as part of the right logical analysis, as a cross-check to do these fit with the differential distribution that seems to be there, what you do see is persistently lower pay for women in all of those grades, in all of those locations, compared with men. The percentage differences are smaller, and they're reducing. And
What is this 111, did you say?
110 and 111.
Yes.
So the percentage differences are small, and they're reducing. And the reason they're small and they're reducing is because you are taking account of the ratio of the pay range to the minimum. And as we know, during this period, the pay range is shrinking as a ratio of the minimum. And that's laudable, because what the respondent is trying to do is shorten the pay scale so it takes less time to progress from the bottom to the top. And in due course, that might eliminate the discrimination in this case that we're complaining about, and it might be a factor that it's relevant to consider at the objective justification stage.
It won't ever eliminate it. How much you shorten it, it will reduce it for the reason you explained, but it won't eliminate it as long as you have differential recruitment.
That's true. It will do two things. It will reduce the value of the differences, and it will mean that those who are already in the system progress faster, all of which may be relevant to matters to be considered at the justification stage. But you're right, as long as you have differential recruitment.
Well, it's two elements. It's having differential recruitment and the earlier differential recruitment not having worked its way through.
Yeah.
Yeah.
Exactly. So that all may be laudable, and that may be something highly relevant at the objective justification stage. But at the particular disadvantage stage, for all the reasons we've developed, it's measuring the wrong thing. But when you look at these statistics in the context of having started with the right thing, which is looking at the distribution, and then testing finally to say, do the average differences seem to support the conclusion that in these pay scales, women are losing out more often than men? And the answer is yes, they do, because there are persistent average differences in favour of men. And that's kind of completely made out when you then compare with the statistics in paragraph 65 of our skeleton, the average variable pay statistics. You then see that actually it's the effect of taking account of the pay below the minimum and the ratio to the range is what's producing that apparent pattern within the total average pay statistics.
You say it could be relevant to justification. That is to say that the figures are small and reducing. as you will know, one of the worries about Naeem is that it puts the employer who deliberately tries to increase the number of women in his workforce, which is laudable, gives, I think I put it in my judgment, he creates a rod for his own back, because he immediately creates a gender disparity, assuming he has length of service as a criterion. This is an unfair question to answer you, but because you'll say it doesn't arise, but you're grown up enough to find a way of dealing with it. Why shouldn't that be a sufficient justification in itself?
Because it's two separate questions. It's one thing to say this is a workforce within which historically we've not managed to recruit enough women, and it's a good...
That shouldn't be... The fact that you may have culpably by some social standard, not recruited enough women in the past, can't be relevant to the effect of what you're doing now you're doing it.
Exactly. Once you resolve that problem, laudably as you should, by recruiting more women, then you have to treat all of those people equally, both in terms of not directly discriminating, but also not maintaining practices that then disadvantage.
But the only answer to that will be not to have length of service as a criterion at all, and it may be a justifiable criterion.
Well, no, but if it's justifiable in its own terms, then you can still have it, because it's not unlawful. This is Baroness Hale's point in Naeem, that you shouldn't be afraid to reach the justification stage. But if you've just recruited a load of women, and they're at the bottom of your pay scales and disproportionately, therefore, disadvantaged compared with your longer-serving men, and you have no good reason for doing that, it's not justified, it's not proportionate, then you shouldn't do it. If you've got a good reason for still doing it on its own terms, then you can still do it.
Okay, thank you.
Well, Mr. Cooper, what then is an employer in the position of the respondent to do? If it wants to preserve the reward for long service, but also wants to correct what, for historical reasons, is a preponderance of male employees. You say, well, if there's a justification for preserving long service, there won't be anything unlawful. But what is the employer to do before it embarks upon the process? It wants to recruit more women. But as my Lord points out, the immediate consequence of appointing more women will be, in accordance with your submissions, an objectionable disproportion, which the employer will then have to justify. So, what is the employer to do?
In short, make sure that it can justify, that it has a good reason for the pay system with the length of service provisions that it has. And to bring it back to this case, to where we started, this of course isn't a case where the employer has set pay points which reward length of service axiomatically. It rewards it sporadically, depending on the pay award each year, and it happens that its decision to recruit more women, or it's the fact of it more recently recruiting more women, has coincided with a period where it basically stopped moving people up the pay scales because of austerity. Now again, those may all be perfectly justifiable, and we may need to consider those at the justification stage. But I think it's the internal grievance manager used the colourful phrase, it's as if the employer has recruited more women and then removed the ladder for them to climb up the salary scale. So these are all legitimate questions, but they're not questions for which there is no answer for an employer and no ability for an employer to protect itself. If an employer wants to have a pay system of this kind, which doesn't reward pay length of service axiomatically, and in which you end up with people on 100 different pay points within a pay scale, then it's making a rod for its own back.
So even that, it might be able to justify.
It might.
Just probably rather less easy to justify, you would say.
Yes, exactly.
But on that approach, the answer to my question is that what an employer is to do is to metaphorically cross its fingers and hope that it will succeed on justification.
Well, it's a little more than cross its fingers. It should consider carefully the pay practices that it's operating and decide whether they're genuinely necessary.
Yes, of course, but there will be marginal cases, perhaps.
Yeah.
But is that what it boils down to? That if the employer isn't 100% sure that it will be able to succeed on justification, it either doesn't recruit more women, or it recruits more women and hopes for the best.
Save that the first option isn't lawfully open to it.
Yeah, well, quite. So this is why I asked.
Well, it's not quite as straightforward as that, actually. Clearly, if women apply and you turn them down on the basis that you'll create an equal pay claim for us, that's not lawful.
Yeah.
But you might fail to take proactive steps that you might otherwise do to make your jobs either more known to women by advertising or more attractive to women by changing the characteristics of the work, which is generally how progressive employers try to do it.
Yeah.
It won't always be unlawful.
No, that's all true, and the answer to it is they are two separate questions. The employer should, as a matter of good practice, be doing what you've just described, but having done that, which no one is going to criticise, it is then incumbent on the employer to scrutinise carefully its pay scales and check that they are justified.
I think it perhaps comes down to a point which Lady Hale does squarely confront. Employers tend to take the view, my Lord has articulated, that justification, though it may sound very nice and objective, and as long as you try hard you can do it, experience of tribunals, maybe anecdotal, maybe unfair, is who knows what's going to happen when you want to defend your pay practices in an employment tribunal. Lady Hale would say, well, try.
Yes. She says, as you say, she confronts it directly. There's no shame in reaching the stage of needing to confront, and we shouldn't be reluctant to reach it simply because we have a sense that tribunals, and I suspect this is a bit unfair, tribunals are a bit of a lottery on that. Where they are less of a lottery from experience is where you have an employer that has conscientiously considered the points, can show that it's thought about them.
50-50 balls tend to go their way.
Then 50-50 balls tend to go their way.
But in any event, you would presumably say that this is a commonplace, where you have, as you submitted to us earlier this morning, imposed pay settlement, or perhaps even where you have collectively bargained pay settlement, but most certainly where you have imposed, there are intended and unintended consequences.
Yes.
And these have to be thought through.
They do.
And austerity adds to that.
It does.
It's just a circumstance the employer has to face.
We've strayed into it's the first subsidiary point I was going to come to. So we've strayed into my next point, which is to address my Lord's point on how this then fits with the individual claim and justification. First of all, how it fits with the individual claim. Going back to the structure of Section 69, you start with the individual difference in treatment, you identify the cause of that, and then you identify whether that same cause causes a particular disadvantage to women in general. And if there's that causal connection both to the individual and to the group, then that's sufficient. See Lady Hale in Aesop at paragraph 33. That's sufficient to make out the individual claim. So I am paid less than my comparator because I have shorter service. Shorter service, as it operates within this pay system, places women generally at a particular disadvantage. Same causal factor, I succeed in those parts of my claim. And then you move to objective justification. So that's how it fits in with the individual claim. In terms of objective justification, the point that is taken against us by the respondents and accepted by Mrs. Justice Simler, as she then was in the EAT.
As she still is.
Oh, yeah, she's not quite. Accepted by Mrs. Justice Simler in the EAT is that if you make your case by way of looking at the disparate impact, then it's the disparate impact or the distribution that you then have to justify. Now, with respect, that's not quite right, because what the authorities are clear you have to justify is the use of the factor, the operation of the factor, the application of the pay practice in particular. Can I just go really briefly to two authorities on this? First of all, back to Enderby at tab 7. And paragraph 25.
Did you say 20?
Paragraph 25. Court has consistently held, it's the fourth line, that what has to be justified is the adoption of a pay practice. And then through to 28 makes the point that justification is not an all or nothing. It may be possible that part of the difference is justified and not all of it. And then Homer again at tab 20. Also at paragraph 22. 23 in fact. Page 712. Where she, that's Baroness Hale, picks up on a suggestion by the Employment Appeal Tribunal in that case that what has to be justified is the discriminatory effect of the unacceptable criteria, and she rejects that in terms. She says this isn't, Mr. Lewis points out, this is incorrect. Both the directive and the regulations, as they then were, require the criterion itself to be justified rather than its discriminatory effect. So what you're looking at the justification stage is the use of the factor in question, the operation of the pay practice in question. And it's that has to be justified.
That makes it even more clear that you're not interested in value at the earlier stage.
Exactly. And as part of the assessment of justification, you do of course have to apply the principle of proportionality. So that will or may include, depending on the circumstances of the case, the discriminatory effect of the factor and also the value of the difference that it produces. So if you have a reliance on length of service, but it only produces £100 difference in pay, that may well be proportionate to the additional experience. But if it's a £20,000 difference, you'll probably need to show something stronger to explain why that's proportionate. Similarly, if the disparate impact is relatively small, it may be easier to justify than if it's a significant discriminatory effect. But there's nothing in the statute, in authority or in principle, to stop you taking account of all of those elements as part of the assessment. And indeed, my Lord Justice Underhill will be familiar, we frequently do when we look at these questions of justification. obligation, I've certainly always taken it as axiomatic that you put all of those factors into the mix as part of the assessment of overall proportionality. And for those reasons, in our submission, Mrs. Justice Simler, with respect, was wrong, and the respondents are wrong to say that if you focus on the discriminatory effect, as in terms of disproportionate effect on women, that alone is what you then have to justify. As Homer makes clear, in fact, that is wrong. Another subsidiary point that I just want to address relatively briefly is in relation to the EHRC code, which both parties rely on, saying it supports our approach and is perhaps therefore an indication that it doesn't entirely actually address the questions that arise in this case, because this is the first time those questions have really been brought into sharp focus. The code you have at tab 3 of the authorities bundle, and the paragraph that we rely on in particular is at page 55 of the internal numbering, paragraph 177.
I was just reading something else. Where in tab 3, page
55 internally,
thank you.
paragraph 177.
Yep.
In the stage of the equal pay audit model that is being followed through here, we've moved past the first stage of working out who's doing equal work, and then the code is recommending what sort of analysis and data need to be considered. Calculate average basic pay and total earnings, and comparing access to and amounts received of each element of the pay package. So the respondent relies on that to say, oh, well, here we're talking about basic pay, so you just calculate the averages. We rely on that to say, it also says you have to consider access to and amounts received of each element of the pay package. Then when you come to the associated guidance, which probably comes into the scope of the statutory code because it's expressly referred to, but probably nothing turns on it, it is certainly right to say, this is at tab 4 of your authorities bundles.
Well, the statutory obligation, strictly speaking, is to refer to the code.
To the code.
What's it? Take account of?
Take account of. You've got, it's in the 2006
we've got
Act, which you've got at tab 1. The code then itself says, please refer to our detailed guidance and toolkit. So whether that strictly brings considering the toolkit within the scope of the statutory obligation is perhaps an open question, but not much, I suspect, turns on it. And the reason not much turns on it is because it is actually pretty clear that the particular issue that we are grappling with, just as it's the first time this court has had to grapple with it, it's not been grappled with expressly in the code. So it's certainly right. There's some internal page numbering at the bottom of these pages from a previous bundle, and at page 138 towards the end of this section, this is part of the toolkit where the Commission is considering particularly problematic aspects of pay systems and identifying about a third of the way down the page long pay scales and ranges as a notoriously problematic element. And at the bottom of the page, identifying the risk that average pay of women on each pay scale or range will be significantly lower than average pay of men. And over the page, how do you identify the risks?
This will occur when women are clustered towards the bottom.
So, and over the page, then how do you identify the risks? It talks about calculating average pay. So in that passage, it talks both about clustering and about calculating averages, and doesn't really grapple with the point that we're concerned with. At other points within the code, not...
The figure of 5% at step 2,
Yeah,
it is a 5, isn't it?
it is a 5. It's not clear.
That's just been plucked out of thin air, is it? There's no basis in the case law for it.
No. Elsewhere, for instance, with the internal numbering at the bottom of the page 110, which is about halfway through, probably these, maybe nearer the front. When the toolkit talks about comparing access to and amounts of pay elements, it talks about both looking at the proportion of men and women who receive the element and the average amount of each pay element of each pay element received by men and women, and the gap between them, and then referring to this will show whether men and women have differential access to the various pay elements.
So I may have been rather unkind to say plucked out of thin air. I didn't mean that offensively, but is there, you've clearly got to have some guidance, and employers need help, but is there any discussion of why they have chosen 5% rather than the other figure?
It's not explained as far as I know, and my lord is right that it doesn't have a basis in case law.
Yeah. Okay, well,
and then at page 105, working backwards through the internal guidance, the toolkit guidance, at paragraph 3.5, no, 3.6, I think it is, just below halfway down the page.
So which page are we now on?
105, using the numbering at the bottom. Differences in proportions, for example, when comparing access to pay elements, and their express reference to the chi-squared test being one measure of statistical significance in relation to that. So the short point in relation to this is one can draw support for both sides. What it does make clear is required is careful analysis of your pay, all elements of your pay, and both averages and access to and amounts of different elements. And it doesn't grapple directly with the points of principle we're concerned with in this case, and therefore doesn't really give us the answer to the question or take matters much further. That, I think, brings me to the reasoning of the ET in this case. And within the judgment, if I could start at page 145 of the core bundle, just to highlight, as I mentioned earlier, at paragraph 20, the judge accepting, as indeed was not in dispute, that the figures relied on by the claimants confirm the clustering asserted in the pleadings, and he would allow those to speak for themselves. Before jumping back in a moment, could I then jump to paragraph 40 at page 150? Where the judge notes in the third line that the rival evidence does not meet head on, and that's really the key to how this case has gone all the way through. And the reason it's gone like that is because we've all started from different premises, and it's the different premises that I've been banging on about all morning. The evidence didn't meet head on because the respondent's evidence was seeking to address how do you assess the significance of pay differences, and our evidence was seeking to assess how do you assess the significance of a distribution, a disparate impact. And you can see that if you then go back to the judge's references to some of the expert evidence at page 146, paragraphs 27 and 29, where he notes that Dr. Hall, our expert, confirmed the basic facts that underpin our claims, and in particular the clustering. And then in relation to Dr. Brown at paragraph 29, records that he gave reasons why in his evidence for his view that average figures were the best measure by which to assess the statistical significance of pay gaps. And he explains some of the choices between mean and median, and says he favoured using the mean to interpret and evaluate differences in basic pay. So there you see, starkly right at the beginning, the two ships sailing in different directions. The claimant's expert and claimant's case focusing on disparate impact, and the respondent's case, expressly per Dr. Brown, focusing on significance of pay gaps rather than disparate impact. And
there is a problem here, isn't there, which feeds into a wider problem about, there's a lot of discussion about gender gaps, and which is what equal pay audits are looking for, and that goes wider than looking for unlawful acts which are differentials which are unlawful under the Equal Pay Act.
Yes. To be fair to Dr. Brown, I don't think he was focusing more widely than the particular grade in this case, but his premise was the same premise that the respondents argued for and the ET and the EAT accepted, that you have to assess the significance of a pay gap, and you can't assess or supplant that with an analysis of disparate impact. And I don't want to spend a long time going through notes of evidence from below, because we're not, I appreciate, re-arguing the case here, but just to make good the point I made to my Lord Justice Ryder a short while ago, that Dr. Brown accepted in terms that was his approach. In the supplemental bundle at page 288, we've got notes of his evidence. We've got in table form both the notes of my instructing solicitors and those of the respondent solicitors. For all my purposes, I'm content to go with the respondent solicitor's note. And within those, if you turn to page 289, you'll see on the right-hand side, early on in my cross-examination of Dr. Brown, I checked with him that he was not asked to consider the appropriateness or otherwise of testing distribution or using it to test the impact of length of service on pay scales, and he said no. Nor was he asked, as he agreed in the next box, what was the best methodology for testing distribution. So he agreed in terms that his evidence was not directed towards considering the appropriateness or otherwise of testing distribution or using it to test the impact of length of service on pay scales. So the short point in my submission is that he therefore set off in all of his evidence in the wrong direction, because what we expressly have to consider under section 69 is the causal impact of length of service as regards the incidence of difference between men and women. And then, whilst we're looking at this evidence, I'll just make a number of other points. I'll ask you to turn back to page 248, just to pick up on one further point before going back to the notes of Dr. Brown's evidence. 248 is part of the points of disagreement and agreement between the experts recorded in a note prior to the hearing. And you'll see the same point is reflected here, just back on the previous page 6. If the question is whether put to a particular disadvantage in terms of basic pay, then there's the discussion. And then at 7, if the question is whether women in grades 6 and 7 are put to a disadvantage in terms of their distribution through the pay scales, they agree that averages are not particularly relevant. And Dr. Brown did not agree with the chi-squared analysis put forward by the claimant's expert, but when asked what test of significance he would use in the alternative, he replied that he would use one that utilises the continuous nature of the data, but declined to specify a particular test or tests. And he...
So that was the answer to the blank 11.
Yes.
I wondered why that was 11. You already answered.
But he maintained that position when I was asking him questions in cross-examination. Yes, the answer to the blank 11 at page 290. I asked him at 10, you say chi-squared is not appropriate, but declined to say what would be suitable, and he says yes.
Can I speak to you about this? How fundamental in the end, in the way now we've really focused on it, was Dr. Hall's evidence, either generally or in relation to the chi-squared analysis, to your case? You could have made your case from the figures without any expert.
We could have done, yes. In retrospect, we might have been better advised to. Yes, we could have done, and we certainly always did put our case squarely and primarily on the clustering.
And that's your answer to the proposition. Well, hold on a minute. The first instance judge appears to have made a finding of fact by favouring the revenues expert as against yours.
Yes.
In essence, all of this evidence was before it untrue.
Yes.
It was all there on its face to be analysed.
Yes.
And if it wasn't, then it was ignored.
Yes. And just very briefly to complete the picture in relation to Dr. Brown's evidence, at 292, despite my pushing, he again declines to specify any other test. He says you could use better tests than chi-squared, and the test being advanced by us, but never rises to the bait of saying how you would actually do it. And then at 296, agrees in terms at box 34 that averages don't help you with distribution. And then at 301, box 49, makes my central point that I made just before we broke, that averages and distributions are not looking at the same thing. So that's my point, that they represent a choice between two different things that you're looking at. And then lastly, although as I accept he never relinquished his position that use of chi-squared to check the significance of the quartile analysis was not appropriate, the basis of his objection being that what you're doing is you're lumping together different data into single points, which is not entirely accurate. But on a little probing, he did, if you look at page 308, accept, because in fact he'd done it, that you can apply chi-squared to that, because unless you have reason to think that within each quartile that the lumping together is not appropriate because it's masking something else happening within the quartile, you would expect, all other things being equal, the distribution to be equivalent.
just want to make sure how much all this mattered about chi-squared.
But it doesn't really.
Not as my general point about how you could have done it from the figures, but this particular point about chi-squared is that it is to exclude the possibility that these are random fluctuations of a kind you would expect to occur by chance.
Yeah.
Mr. Linden may take a different view, that I suspect he won't, but when you actually just look at the actual numbers or percentages, I think on any common sense view they are greater than could occur by chance.
Yeah.
And everyone agrees why they occurred. It isn't by chance, it's because you've been... So why does chi-squared matter?
It doesn't, and I'll stop banging about it. My Lord makes the two central points that we've always made in relation to that. I made the first point to the tribunal and to the AT. You don't need to get to chi-squared or anywhere else because all you need to do is look at the clustering, and in this case, it hits you between the eyes.
And I'm sorry, but it's common ground that you had been recruiting, or they had been recruiting more women deliberately.
Exactly right.
So it was bound to happen.
Exactly right.
Right. That might not have bound to happen, I suppose. First they might have failed, but I mean, I think that's being too fancy.
Yeah, that's the second point. Is in a normal fact-finding function of a tribunal, you don't need to get in statistical tests here because you can just look at the figures and then you can consider the known facts and you can say the only possible conclusion is that women are disproportionately clustered towards the bottom because they've been recruited more recently. Let me go back to the tribunal's reasons then and pick up the core reasoning that the judge relied on to find against us, beginning at paragraph 43. And having been through, I think, all of the key arguments in advance, I can take these fairly quickly. At paragraph 43, the judge goes wrong right out of the gate because he says, in the second line, in the first place, I agree with Mr. Linden that distribution cannot be equated with or allowed to supply pay. The law is concerned with ensuring equal pay for equal work, ascertaining distribution of men and women within any particular segment of the overall sample may provide a partial picture of apparent advantage, but it says nothing about actual pay difference within or outside the segment. So he goes wrong straight out of the gate because he rejects, as a matter of principle, a distribution-based analysis and wrongly says that section 69 is focused on actual pay differences when it's not. It's focused on the causal effects of the relevant factor. At paragraph 44, he says there is, it ignores the undisputed reality that as the average figures show, there is no significant long-term difference between the basic pay of men and women in either of the two grades, which is not an accurate representation of what those figures show. They do not show an undisputed reality. They show a particular statistical representation of the overall pay in those grades. And this is the part of the problem of equating average pay with reality. There's this persistent and wrong approach of thinking that average pay, perhaps because it's easier to understand, is real and distribution is somehow abstract. But they're both just statistical tools. Then given that reality, it necessarily follows that insofar as selective analysis based on deciles, quartiles, or any other slice of the total grade population reveals a clustering phenomenon apparently favouring men over women, there must be a more or less counterbalancing advantage the other way within and or outside the relevant decile, quartile or other slice. Now that is put in terms by the judge of a logical and axiomatic conclusion, but it's anything of the sort. As I understand what he's saying there, saying if you've got small average differences, as we do here, and clustering, then in order to explain why the average differences are small, you have to conclude that within each quartile or decile, actually women are clustered up the top of that decile or quartile and men are clustered down the bottom of that decile or quartile.
On your case, it's an error of fact of significant proportion.
It is. It is perverse. There was simply no evidence before the judge that within any decile or quartile that was what was happening. And what the judge completely fails to do here is address the explanation which I gave him for why you get small percentage figures, which is the one I banged on about a lot to you, so I won't repeat, but it's the taking into account the variable, the non-variable bits. And he just doesn't address that anywhere. Then at paragraph 45, he says, I'm much more impressed by the evidence of Dr. Brown. I accept its entirety. It satisfies me that the statistics relied on by the claimants are statistically insignificant. Well, that's an attempt to kind of wrap up in a finding of fact based on evidence that the whole shebang, but it suffers from the problem that Dr. Brown's evidence started out from the same wrong premise that the judge starts out from, as I've shown you, and it doesn't address the obvious conclusion that when you look at the figures on clustering in this case, the conclusion is inescapable. Paragraph 46, I agree with Mr. Linden that it is not permissible to divide basic pay into separate elements in order to challenge the length of service criterion, which again is a misrepresentation of what we're doing. We're not dividing basic pay into separate elements. What we're doing is, as a matter of logic, working out how to analyse the causal effect of the relevant material factor. And if the relevant material factor only operates within a defined and identifiable part of pay, then why is it logical to bring into account, when analysing its causal effect, the bit that it doesn't causally affect? Paragraph 47, I agree with Mr. Linden that a distribution-based approach favoured by the claimants would be unworkable in practice and liable to produce most undesirable results. No employer could be sure of escaping liability. That's in part the point that I was addressing with your lordships a short while ago, but insofar as it's suggesting that you have to look at abstruse statistical analysis, that's not right. See my answer that in fact they did it themselves in this case with their internal grievance, and this isn't a case where in the end you need to get into abstruse statistics.
He certainly wouldn't have used the language of, or at least be being put at risk in having to make out objective justification if naive had decided at that point.
Yeah, exactly.
That's
Sixthly, the logic of the claimant's case does indeed, as Mr. Linden pointed out, admit the possibility that distribution statistics could establish the particular disadvantage of one gender group in respect of basic pay in a case where overall mean figures showed by reference to the same term that it was substantially advantaged. That's the point I mentioned a short while ago. He seems to think, Mr. Linden still seems to suggest, that you could have a case where there's differential distribution in favour of men, but women nevertheless have higher average pay. I'll be interested to know how that happens. And I'll reply if need be. Seventhly, at paragraph 49 is the code of practice, which I've addressed, and then that all leads to the conclusion at paragraph 50. So, my lords, for all of those reasons, which all essentially come back to the fundamental point I started with, and which all essentially flow from the wrong turn the judge takes at paragraph 43, in my submission, his conclusions were unsustainable, both as a matter of, both because he erred in principle in the direction he took, and because at paragraph 44 he reached conclusions which simply weren't open to him on the material before him. My lords, it's just after 3 o'clock, and I could do a similar exercise with the EAT judgment, but the points are largely the same. So I mean no disrespect to Mrs. Justice Simler, and I'm happy to do it if your lordships would find it helpful.
I think you're right. I mean, that well, I suppose the trite point, we are basically concerned with the ET, right, not right, with the EAT, right? That's less true that sometimes it's just these are pure points of law. And if the EAT puts it better, then we should look there. But it really is all the same points, I think. If there are particular points that Mrs. Justice Simler makes, which Mr. Linden relies on, you can deal with them in reply.
Yes.
Right, thank you.
My lords, unless I can assist further.
No, that's been very helpful, thank you.
My lords, can I start by saying something about the facts and then go to what the issue was before the Employment Tribunal, and then develop my submissions in relation to the main ground and as it were, sub-ground 1. In relation to the facts, obviously you've read the materials. I just wanted to address some of the things that Mr. Cooper was saying. As his argument essentially being premised on there being a fixed point above which from which people progress in relation to their pay. So I wanted to just look at what the factual situation actually was. And firstly, as to the nature of the ranges, you've obviously got the point that they did not reflect or contain increments or steps on a ladder. The only significance of the range was that it stated the minimum that an individual in the grade could be paid and the maximum which they could be paid. Second point, as to what you were paid within those bands, it was not the case that you necessarily started at the floor of the grade and then worked your way up. Nor was it the case that prior service was irrelevant in all cases, for reasons I'll show you. Maybe go in that connection to core bundle page 183.
Shall I just be clear what we're going to it for?
Yep.
If it's to say you don't necessarily start at the bottom, that means that people are sometimes recruited in the middle of the range, either internally or externally. Is that right? I'd certainly pick that up, and I'm not surprised that is the case. But conceptually, does that make a difference?
Well, what I'm going to come to when
on the assumption that you can't drop down, which you obviously can't.
Well, what I'm going to come to in due course is what the issue was, given the factual context.
Right. You'll just want to make it the fact.
Mr. Cooper's submissions are on the premise that there was no issue as to the fact that a system including annual pay reviews led to a disadvantage in relation to pay, and in particular a disadvantage in relation to women. And I'm going to show you in due course that actually there was a dispute as to the impact, if any, of that aspect of the system, and as to whether it impacted on women in particular, or adversely on women in particular. I'll develop the point in a moment, if I may. So the first point is that the bands simply reflect the maximum minimum you can be paid if you're in a particular grade. Second point, where you started in relation to a particular grade was not necessarily the floor, and as my lord has pointed out, just for your reference, I was going to go to the grounds of resistance, paragraph 22, core bundle page 183. Your pay might be, where you were on the range, might be affected by what your pay was if you were recruited from outside the civil service. But secondly, it might be affected by whether you were promoted from a lower grade. If you were promoted from a lower grade, it would depend on what you were being paid before promotion, because you would receive a minimum of an 8% pay increase. And so if you were close to the maximum of the lower grade, you would go to a point higher than the minimum in the
Did grades overlap at all?
Oh, I don't think they did.
No.
Not on the charts we've been shown.
Sorry?
Not on the charts we've been
That's
shown.
Lastly, under this heading, for those who were recruited prior to assimilation, as between the Inland Revenue and Revenue and Customs, where they were was affected by where they'd been at the time of the assimilation exercise. Mr. Cooper has said a number of times, well, the only effect that length of service had was on where you were above the minimum on the particular grade. That is true to an extent, but it's not as simple as that, because if you were recruited at a significantly earlier stage, before 2006...
That's why I do see these complications, and these systems are always much more complicated when you look at them in detail. But at the moment that you're going to come to, I can't see why it makes a conceptual difference. Perhaps you shouldn't have said below the minimum. Perhaps you should have said below your starting point.
Yes. Well,
But I suppose...
I'm going to say it doesn't make a conceptual difference. I'm in due course going to say that the court will obviously have appreciated that the argument that Mr. Cooper is putting would not simply apply, for example, as my Lord asked, is this about the public sector, it wouldn't simply apply in the public sector, and it would not apply necessarily to cases where you had grading systems with a particular maximum. And that is because the ultimate complaint that Mr. Cooper makes is a complaint about awarding annual pay increases which are then applied to your existing rate of pay. The consequence of which we agree is that the more years you're there, the more opportunities you have for an increase in pay.
That time of the afternoon where one slows down. You say this won't just apply in cases where there's no maximum. Are you saying it won't apply just in cases with no minimum either?
Well, it will. The logic of his case is that his proposition to the Employment Tribunal, to the EAT, and to you at least in the skeleton argument, was that in what's been called this type of case, the only underlined paragraph 39 of his skeleton right way to measure the question of particular disadvantage is to make a differential distribution based analysis.
Yes, I've got that.
So cases of this sort, as I understand it, on analysis, are essentially cases where on an annual basis there is a pay award which adds to the existing pay of the employees.
Well, that's virtually any employment.
Yes.
That's your point. Yeah.
Well, that's rather looking ahead. That you've taken me out
But
significantly
they will, of
advanced
course,
work.
yes, all right, I'm sorry, but they will have to be cases of equal value, which
Yes.
classically will only be establishable, or most easily establishable, where there's a grade based on value, based on equal value.
Well, most easily established, but as you appreciate, that's not a requirement. So, as you know very well, my lord, from your experience, the fact that you can make a comparison based on equal value obviously means that it's not a requirement of the legislation that the comparator is doing the same job as you are. All that's required is that you can show that by reference to the demands of the job, the work is of equal value. And so that obviously means that in a given workplace, on the logic of Mr. Cooper's argument, provided the comparators are doing work of equal value, then he is submitting that the only, and secondly, the way that the employer approaches the question of pay is to award annual pay increases applied to existing rates of pay. Mr. Cooper's proposition is that the only way that you can measure particular disadvantage is a distribution-based statistical analysis.
I'm sorry, I took you out of your course.
Not at all. I was wanting to, at this stage, that's taking me ahead, but it's no problem at all, obviously. But at this stage, what I was wanting to identify was what the issue was in the employment tribunal, and to draw a contrast between that and the typical PCP case. And in due course, I'll be submitting that the position was actually rather closer to an NWB type of case. And I'll say that in order to reach a view about particular disadvantage, you did need to have an idea of the actual impact in terms of pay of the criterion complained of. But I'll come to that in a moment, if I can just lay the foundation by reference to the fact.
Sorry, I would say one more thing and I'll shut up, but it's almost, you're saying, it's not so much a length of service case as a passage of time case.
Exactly, because the reference to it as length of service can mask, obviously, other complications with the case. There are pay systems, as the court will know, where for each year of service you get an extra pay increment. That's not the nature of this case. The nature of this case is that the complaint is essentially that each year a decision is made to increase the pay of the relevant workforce. So there's an annual pay review, as commonly occurs.
Yes,
And
we'll come back to it when we get to the heart of your case. At the moment, though, I don't see why it makes a conceptual difference. I think it may create practical differences, whether what you have is a fixed point or an annual opportunity for an increase, which in practice will be an increase unless you underperformed. I don't quite see why that makes all the difference.
Well, it may have an effect on, if I can put it just in very broad terms, on the overall merits. If you have if the real system was one in which everybody starts the minimum in a particular grade and they then go up incrementally in year on year according to set increments, then one can see from the point of view of comparability and fairness that you can then ask the question about whether that is having an appropriate disadvantages women and so on. But if the situation is a great deal more fluid, as I'm seeking to demonstrate, I've got more points to make, well then you do have to bring into consideration, at least in terms of deciding what the law should be, the fact that obviously people who started earlier may have started at a lower minimum. They may have taken a longer period of time to get further up the grade. Because the annual pay increases earlier on in their employment were of a lower percentages than they were during the time of the claimant's employment and so on.
Go on with your other points about fluidity.
About the facts, yeah. Well, the first point was about the ranges are simply met. Second point, where you're paid isn't simply a function of starting at the minimum and making your way up.
Yeah.
Third point, the floor and the ceiling are not fixed points, other than in a particular year.
Oh, sorry, I dropped down a third point already, which is those recruited prior to assimilation, where they were dependent on.
Well, I'm happy to call it the fourth point. But
okay, so the fourth point is, tell me again.
That the floor and the ceiling of the grade are, the minimum and the maximum, are adjusted each year.
Are they adjusted formally for cost of living?
They're adjusted in different ways, according. That's what I wanted to show you next. If you look at we go to the supplemental bundle and look at page 315, which is the document we looked at earlier with Mr. Cooper. The court's had an opportunity to look at this document, so I'll take it fairly briefly. You've already taken the point that over the period of time, the pay range is shortened if you also look, for example, at the entry headed 2006 for London, just by way of example.
Sorry, which page are we on? 314.
314, 315.
Yeah.
You can see below 2006, you can see that different increases were given, or different percentage increases were applied to the minimum and the maximum in each of the years, and sometimes no increase. So Mr. Cooper very fairly said that as a matter of policy, there were various steps taken to shorten the pay ranges, and those included giving greater percentage increases to the minimum or people at the bottom of the pay range than were given to those at the maximum.
There are one or two oddities. There's obviously something funny about the SO grade, but we needn't worry about that. It's the minimum doesn't increase, the maximum does. Am I reading that wrong?
Where is that, my lord?
2006. In fact, sorry, to be slow about this, G7 and G6, which is what we're concerned with, in 2006, the minimum, the maximum increase in step for G7, so that won't produce any shortening of G7. At G6, the minimum goes up by slightly more than the maximum, so that will produce a tiny shortening. Am I getting this right?
You're right.
And then something very similar happens the next year, and then the shortening begins to gather pace. So the shortening gets faster as we get into the period, which is actually these first few years we're not concerned with anyway.
That's right.
Yes, I see. Thank you.
So, nextly, and in connection with that document, the annual pay rises for individuals would obviously depend on where they were on the pay ranges. So, those at the maximum would get different percentage pay increases to those who are at the minimum.
Yeah.
And as you gather, the result of those various different considerations was that you then had a very large number of different rates of pay within each of the grades. My lord, for your reference, that's supplemental bundle page 193, which shows that in most of the years under consideration, there were more than 100 different rates of pay within each.
May I just look at that, make sure I understand it?
I'm not sure it's a scattered one.
Oh, right.
It's an annex to Mr. Brown's report. Let's see, if you got 193.
Oh, I see, yes. No, so I asked the same question to Mr. Cooper, and he said you could see it on the statograph, but you can see it here as well.
Yeah.
Yes, I see, thank you.
Now, if you've also got the supplemental bundle, and if you go to page A14, which we looked at this morning, it's the core bundle, page 160A14.
A14,
That's
did you
right.
say? Yeah.
Another document we looked at this morning, but first point to make is that there was not a complete data set in terms of the length of service of the individuals within grade. The document that you see at 160A14 was, as it were, doing the best that could be done on the available data. And if you look at that, what it was showing was that length of service or opportunities for annual pay increases was not the sole explanation for the levels of pay. And you get that because if you take, for example, you've got the years of service down the left-hand column, you've got you've then got the average women pay of the women compared with that of the men, and you find that it's not although they have the same service, there's a difference in average pay, and conversely, if you look down, for example, look down at grade 6, you can see, for example, that after 1 year's service, the average pay of the women was higher, although there was the same. They all had 1 year's service.
Sorry,
So,
I'm obviously looking at the wrong one. I'm looking at page 160A14.
that's right. That you've got a mean analysis by length of service 2015
For grade 6 or grade 7?
for both grade 6 and grade
Yes,
7.
which one are you asking us to look at?
Well, grade 7 to start with.
Yeah.
If length of service was the only factor influencing pay, you would expect the rates of pay to be the average rates of pay to be the same as between men and women at each stage in their service. And the only point I'm making at this stage is that they're not, and that was because length of
Sorry,
service.
I'm very slow. Where are they not? They're
If you
almost.
look at grade 7, 5 years service. the
Yes,
average
but
pay
a great
of the
majority are in fact virtually the same.
A number are yes, but a number are not. All I'm on an incomplete data set. All I'm seeking to illustrate at the moment is that there was an issue as to the impact which length of service was having, as well as an issue as to whether it was having an adverse impact on women in particular.
Well, I'm not quite sure I'm there. But in identical cases, you would, a man and woman joining the same time and
Yes.
then looking at them again 5 years later
Yeah.
ought to be being paid exactly the same, the individuals.
Yes.
And if you looked at an average for people
Yes.
in that position, likewise, there might, however, be small differences.
Yes.
I think the only one that could affect it would be performance, wouldn't it? Because where they came in wouldn't affect it, because you've hypothesised people who come in at the same point.
Whether they were whether their pay is affected by the simulation exercise, where they came in, yes, in my submission, that would obviously affect where they were in terms of pay, not necessarily simply by reference to the number of opportunities they'd had for a pay increase.
Yeah, well, right. There's two classes. There's people who come in after assimilation and come in at the bottom of the grade, a man and a woman.
Yes.
Their pay can then only differ thereafter if one has different performance from the other.
If they start on exactly the same point, yes.
Yeah. That's what I'm hypothesising.
Certainly.
I appreciate that the group as a whole will contain some people who are untypical of that.
Yes.
Yeah.
So, all I'm seeking to demonstrate by reference to the fact that the evidential picture that the tribunal confronted was that you then had within that pay system a question as to whether the system of annual pay reviews was having an adverse impact, and if so, an adverse impact in particular on women.
Why do you put it that way? Why do you
Well,
say an
because
adverse impact on women?
Because I'm seeking to draw a contrast between the classic PCP case, which is at the heart of Mr. Cooper's argument. In the classic provision criterion, let's take his point about, well, if there's a requirement that you have 7 years' service in order to be paid an additional £1,000, you would not then engage in an averaging approach. And of course, I accept that, because the requirement of 7 years' service would itself be a criterion for determining whether you get the extra £1,000. But in that type of case, the cause of the difference in pay between a person who's gone past 7 years and a person who has not is common ground. The fact that the extra £1,000 is an advantage and not having it as a disadvantage is common ground. The only issue is as to whether that particularly disadvantages women. in the present case, there was an issue as to what impact the annual system of annual pay increases actually had on pay in the context of a number of other things impacting pay. So the causation issue. And secondly, there was a question, and did it act to the disadvantage of women?
Obviously, I take the point, and it's important to you. I'm trying
Yeah.
to see how you deal with it analytically. That, quite apart from that rather extreme case of someone who simply gets a pay increase after 7 years, but if you had fixed points every year, it'd be very standard analysis to say the PCP is having a system of annual increments.
Yes.
Here, you haven't got a system of annual increments, but you have got a system, if you call it that, of annual reviews. It's hardly a system at all. That's why, in a sense, I called it passage of time.
Yeah.
But is one way of saying what you're saying that there is no factor of length of service? That's just that's putting a label on, as I say, just the fact that the longer you're employed, the more likely you are to get more money.
What I'm saying is that in a case where there is an issue, so what effect is this pay approach having? And there's also a question, is the effect to the particular disadvantage of women? The submission is you have to look at the impact in terms of the actual pay of the women as compared to the actual pay of the men. That's the essential point that I'm making. Because what you're engaging in, as we'll see in due course, I hope, by reference to Enderby, is you're engaging in looking at the statistics and asking whether you can infer that of the various things that affect the pay of the men and the women, that the actual annual pay increases have an effect which is to the particular disadvantage of women. So you have to look at the question, well, are the women actually being paid less as a group? And you have to see what you can infer about why that is, if that is the case. And that's why in our submission you need to look at what the women are actually being paid.
We do see the women being paid less in a group.
It depends on what basis you say that, my lord.
Well, the mean figures,
Yes.
which showed that they were varying between, depending which year and where you looked, 1% and 3% less.
Well, that's where one has to pay attention to the way that Mr. Cooper was arguing the case, that he conceded, the original pleading, as you know, was, well, there is particular disadvantage. That is shown by the fact that women were recruited more recently. It is shown by clustering, and it is shown by differences in median pay.
Well, hang on. It's not really shown by. The reason for it is it's always the consequence of them being recruited being disproportionately recruited recently.
Yeah.
That means that there is clustering at the bottom. That leads to clustering at the bottom. And clustering at the bottom necessarily, logically, means that the group, as a group in the Holroyde, they will be being paid less. And we can see the figures, and they are the figures that you produce and rely on to say, well, they're under 5% or even under 3%.
Well,
But it's the same figures, you're just doing different things with them.
they are the same figures. That's where the way that the case was argued becomes important in my submission. That as before this court, at least paragraph 39 of my learned friend's skeleton, what was being argued was the only way to assess particular disadvantage is the distribution analysis. What was being conceded was that if the approach was based on mean pay, then the figures for mean average pay did not show significant long-term differences in average pay. And that, as the tribunal saw it, and I'm bound to say as we saw it and still see it, was a concession that on the the right approach to the right legal approach, the claimants lost on the facts. Mr. Cooper, of course, says it was the wrong legal approach. So when have you seen the tribunal referring to the undisputed reality? It was the undisputed reality that if the approach was to look at the average pay, then the statistic didn't show significant long-term differences.
But if it's only at the average pay.
Correct. But it's for that reason that Mr. Cooper's case moved, and it's no criticism of him, but it moved from reliance on that to saying, well, actually, it's distribution alone that is the only logical way to test the question of particular disadvantage.
Your answer appears to be, or at least hints of proposition, that the only way in which a claimant or group of claimants can win is if they put a whole selection of personal employment histories rather than statistical evidence before the truth. Because you're effectively saying that if we, this particular employer, choose to have a non-incremental organic mushroom of a system which only has minima and maxima defined by economic conditions from year to year, and you're all in there wherever you end up from wherever you come, and you get differential increases dependent upon either clear or less clear policy objectives, then so be it. Prove it by presumably interrogating the data of as many other women as you can find who may or may not be in a position if you're not going to rely on a differential analysis. Not a very attractive.
Well, it isn't as expressed in that way, but I'm bound to say, with respect, that it's a very long way from our proposition in this appeal.
Well, maybe we shouldn't interfere.
No, not at all. Let me say what my case is. Let me say what my case is. The distribution approach, as you appreciate, in the context of the present case, and as I've suggested, in the context of a number of other cases where annual pay increases are granted, applied to the starting rate of pay, takes a large number of different pay rates and then applies to them artificial thresholds, the deciles or the quartiles, with a view to plotting rates of pay on a range, but not by way of a scatter graph, as the court has suggested, but by way of whether they're one side or other of a particular percentage marker.
Well, as far as I know, there's been reference to a scatter graph. I've not seen one, but the quartile decile approach, while it carries the risk of missing variance within the decile or within the quartile, it could be said to be simply one way of presenting a clustering effect, which could equally be shown by a graph. And if we saw a graph, we would see, being old-fashioned, pink for women, blue for men, more pink at the bottom and more blue at the top. Well, if you like, we can do it the other way around. That is what the figures that were presented in by way of the decile quartile analysis could just as well have been, and for all I know were, presented on a graph.
Yes.
And you would see the same thing. The advantage of doing it in quartiles and deciles is that you can more easily do things with the numbers. I mean, a graph is just ultimately it's a visual representation of lots of individual things. But the cluster, I mean, the real point is the real point being made by Mr. Cooper is simply the clustering gets him home. Because if you look at this group as a whole, more women are at the bottom end and more men are at the top.
Well,
Gets him home until you try justification.
that is ultimately his case, yes. but what the court has to address, obviously, with respect, before we get there, is whether he should get home on the basis that the only logical way of measuring the question of particular disadvantage in a case such as this is a distribution analysis.
Well, I don't know why he puts it. I suspect he's entitled to put it that high, but suppose he put it unnecessarily high. Suppose he said one way I can prove my case is by showing this clustering, and that's enough for me. And Mr. Linden can come along with his averages, but his averages don't undermine my point. In fact, they prove my point, he says, but only defensively.
Well, it's one way he could have argued the case before the tribunal, I accept. He could have submitted to the tribunal that, let's go with...
But if he had, wouldn't there have been only one answer on the figures we've seen which the tribunal could come?
Well, in my submission, no, his own concession was that there wasn't only one answer on the figures. His concession was that the mean figures did not show significant long-term adverse effect on women. That's the...
So you say the ratio argument isn't open to him because he didn't pursue it overtly in the ET.
I do say that the contest in the employment tribunal is here's a pay system. There are a number of variables that impact the pay. What is being said by Mr. Cooper is that the only right way to assess whether it's disadvantaging women is to engage in a distribution analysis. What was being said by our side was that the right way to do it was to look at the average pay of women as a group.
Yeah.
If that showed a significant adverse impact on women as a group, then we would lose. But Mr. Cooper was not submitting that we lost on the average figures. He was accepting that we won on them. That's how the argument came about.
I don't quite see how... Okay, suppose he can't go back on that concession. I still don't see why it stops him winning on his main point.
His main point being whether a distribution analysis is the correct approach.
Yes.
Well, the direct answer to that point is what we'd submit is that looking at the distribution approach may indicate that there is a problem. What you then need to do is to look at whether there actually is a problem by reference to average pay.
Your submission is distribution can only ever raise a hypothesis.
Raise a potential issue as to pay.
Well, I was probably wrong because I'm not a scientist, trying to use scientific language. But I said raise a hypothesis, which then has to be tested by experiment, and the experiment is the average.
Well,
That was probably I'm showing myself up, but
no, not at all.
but you're saying the ultimate test is always the average, and that all the distribution do is a pointer that you ought to do the exercise. Is that it?
That's right.
And as to the subsidiary argument that there's more than one way of proving the hypothesis, one of which is to extract out the fixed point and look only at the variables.
Well, our submission is that if your case is that the only way to test it is distribution, then our argument is that then your case is wrong in law.
But I want
For reasons I'm going to come to.
test it a
Yes.
little bit
Yes, I understand.
in exactly the same way that my Lord is doing.
Yes.
If you get past the hypothesis and the figures are before the tribunal, is that tribunal supposed to ignore the difference in effect when one looks at the variable element of pay upon women and men?
Yeah. I'm going to come to that argument. My answer is that the tribunal should look at, in relation to particular disadvantage, should be looking at the term of the claim, the terms of the claimants as to basic pay, and comparing it with the terms of the comparators as to
You
basic
said
pay.
the answer to that's the indivisibility of the term.
Yeah, I say that's clear on the statute when we get to it. Can I just since
Yes,
we're
I think we better let you get on.
well, no, since you're engaging me on the as it were the fundamental questions in the case, yeah, point we make about the distribution analysis, there are various points I'll come back to in terms of the practicalities of it. But in terms of whether that is a reliable indicator of group disadvantage, my Lord referred to. Sorry.
No, but Mr. Clare, it's not an indicator. It is a group disadvantage.
Well, we say as a matter of law it isn't.
But I'm not talking about law. I'm talking about common sense. If you've got 100 women,
Okay, well that's
you've
what
got 100 women, and 60 of them are in the bottom half of the analysis, and only 40 above, and the proportions are the other way around for men. Doesn't that show that group disadvantage?
Right, let's look at that then. If you divide it, for example, in quartiles, then you may get a very, very, very clear result, which then will clearly then be reflected in mean pay, and will clearly show that the average pay of the women is lower than the average pay of the men. But you may not get such a clear result, and in any event, in my submission, you would wish to check, you wish to go further. Why is that? Because you may, for example, get more women in the 25th percentile, which is obviously a range of pay. Sorry, fewer women in the top, more in the 25th percentile, fewer in the top 75th.
Yeah.
Top 25%. But you would still wish to ask, yes, but for example, in the top 25%, is it the case that all of the women are being paid the maximum?
Yeah.
And the men who are in the 25% are actually being
clustering
paid
around 75.
around 76%.
Yes, exactly.
And similarly, at the bottom 25%, you may see, well, there are more women who are in the bottom 25%, but are they at 25%, and are the men all on the minimum?
Yeah, I do take that point.
Yeah.
And I take it conceptually, and it's important. But doesn't it then become necessary to see whether that is in fact happening? Depends, obviously, on the. You can make certain working assumptions about the smoothness of the graph, so to speak, which may turn out to be wrong when you look at them, but create, as it were, a working hypothesis that the trend is the same all the way through. A steady downward trend, and then you want to see whether that's a realistic hypothesis. Well, that helps you to look at what the cause of it is, and the cause of it, as we're all agreed, is differential recruitment, which will be likely to have such a result.
Well, the cause of it, you have to. Our argument is you have to get to it. In the end, has to be particular disadvantages to pay. Can I take two strands of what my Lord had said to me?
Yes.
Firstly, the point about plotting it on a graph. Now, one of the criticisms that Dr. Brown made was that the distribution analysis is really ultimately a visual analysis.
Yes,
and what you do is you divide it up into 20, at this point, quartiles. You then put the employees into it, and you then have a look at on the material before the tribunal, the numerical result. My Lord is advocating, well, what you would do is actually, if we take grade 6, take the 1,200 employees and plot all of their pay in red or pink, in blue or pink as the case may be, on a graph, and then have a look visually to see, you always look visually, obviously, take a visual check to see whether you thought, well, it's a lot pinker in the lower down the graph, and a lot.
Yes, but
Yeah.
depending how pronounced the effect was, that might be 100% reliable. Or if it was, you might have to do more work with the figures. What? Suppose it was. Am I not right that?
Well,
In what circumstances? Suppose to the ordinary look, it looks as though it's all pink at the bottom,
you might-
except for a few outliers up there, and vice versa. You wouldn't need to go any further, would you?
You wouldn't need to, I agree, if you've got an absolutely stark result. But if you get a relatively mixed result, then you would want to go further.
Yeah, well, I do see that.
You can say, well, I'm seeing, if I colour in the graph, I can see what I can see. But is it actually?
Were there graphs, by the way? I've been told there are graphs, but there weren't graphs of this character.
I had a recollection of seeing one, but we haven't been able to find it.
But the point about a quartile decile analysis is you haven't got a graph, or you've got a sort of, I don't know what you call this kind of graph, but with step points in it.
The point about the quartile approach, let's pause there, is that you don't even have a scatter graph because you aren't actually looking at the individual rates of pay on the scale. All you've got is individuals grouped according to which
I do see that.
stretch you're in.
But
now
it wasn't a decile. Okay, go on.
Well, one way to go, my lord's advocating, I don't advocate it, is to say, well, no, that's not sophisticated enough, because there may be cases where you get a clear result on the graph, which will, of course, of necessity correspond to differences in average pay of the women as compared to the average pay of men. But there may be other cases where the result is not visually clear or clear in any other sense.
I see that.
So what do you do then? And in my submission, taking as it were, a rough and ready assessment of a visual result in my submission would be inappropriate. So
if it isn't obvious, then you're obviously right.
So that's one reason why, for example, if you're going down the distribution route, you do then need to have a test to see whether the result in terms of the distribution of the pay of each of the individual employees is a statistically significant result.
Yes.
Now, the approach that was actually advocated by Mr. Cooper was not to do it was not to produce a scatter graph. What it was to say, well, look, I take the point that doing it on a quartile basis may give rise to the problems that I've identified. That you may actually, when you analyse the pay of the women, that approach may mean that in fact the average pay of the women is the same as the men, and so on. So what you do, and this is where he coined it in the AT, is have multiple cross-checks, and that's what the decile analysis is.
Yes.
So then what you do is break it down into tenths and see whether you've got the same result. But of course the point made by Dr. Brown was that if you're going to do that, if what you're saying is, well, I'm not really satisfied that a visual representation or a representation by grouping the employees in 25 percentiles is sufficient, I need to look at it in a more granular way. When you go down to the decile level, you're then dividing the pay further, and if you're then not satisfied, you should go down to the 5th percentile, and if you go further, you're then
I get the point. But I get, and that point's it's quite well made by him, and it's well made by Mrs. Justice Simler. But I'm not persuaded, nevertheless, that it's right. If you've got the decile, aren't the deciles good enough? If the deciles show you the same picture.
Well, Dr. Brown was saying the deciles aren't good enough because you end up with numbers of individuals within the deciles which are too small to give you a meaningful result. And so he was effectively saying you should just follow the logical continuation of what you're doing when you go from 5th percentiles to deciles is to go to the averaging.
Yeah, well, I agree. That is what he said. But then you have the problem, if there is a clustering effect, or if there is an effect of differential recruitment rates, which, a matter of common sense, there's bound to be some, then there will be a differential in the averages, which indeed is what is shown.
There's bound to be some subject to there being no pattern of women getting promoted, for example, out of the grade into higher grades. I mean, that lots of assumptions are being made.
Isn't one of the fluidity points you made? You mean women may be promoted out of the grade more quickly?
Yeah. So I don't say there's a finding by the tribunal that that's what happened, but all I say is it's very easy, and especially when Mr. Cooper puts the case so persuasively, to be lulled into thinking, well, this is really a case about progress between a fixed starting point and a fixed end point, where the only thing that influences progress is the number of opportunities for a pay increase. And of course we know that there've been more women recruited recently, and therefore it's not surprising to find them clustered at the bottom, because of course there's some women who weren't recruited recently, and there's a question about what happens to
I
them.
understand that.
Question about
But
men
the point
who
about more,
are graded soft.
but it's about a disproportion.
Can I just continue with my point about distribution versus mean?
Yes.
I made the point that the logic of doing the multiple cross checks Mr. Cooper was advocating before the EAT, at least, reducing it to the decile and so on, is to identify the mean. And my lord said, well, the mean doesn't is not being used in this case as a test of frequency in the course of Mr. Cooper's submissions. But of course, when you identify them, when you assess the mean, what you're doing is guarding against the possibility that for every woman who is paid below a given line, there is a woman paid above a given line who cancels her out. So you're meeting the concern that, well, the distribution effect may in fact be masking the fact that the average pay is the same, or so on. And you're saying let's look more closely at that, because it may well be that the women who are clustered at the bottom are cancelled out by the women who are at the top.
But you say I mustn't, but if we can leave out all the confounding factors like women being differentially more quickly recruited, subject to that, the necessary effect of a differential recruitment is that for a period there will be a lower average for women.
Well, depending on whether they're promoted, in which case
I know, I'm saying, can we leave all those out?
whether they're brought in. Oh, I see. Right.
No, but okay, but it helps. I know you'll say I mustn't, and I'm promising I'll bring them back in later. But in order to understand what's going on, in a pure case, it must follow from differential recruitment of women at the bottom, ignore the people who start in the middle and so on, that for the time it takes them to work through the grade or to get more than halfway up, they will be, women as a group will be paid less than men as a group, and the average will be different. But the average may be quite small because it only affects the variable portion. Yeah. And isn't there a risk that looking only at the average, which is exactly what happens here, you produce the average, ignore the point about whether Mr. Cooper can now try and use it for himself. You produce the average, which shows a persistent differential throughout, but not one that most people would regard as significant because it's 1 or 2 or 3%. But is that a complete answer to say, well, the average, although it does show a persistent differential, it's only a small one, so we can ignore it?
Well, the way we were putting it was that the differential was not such that you would draw the inference from the statistics that the system of annual pay increases, bearing in mind the other variables, was to the particular disadvantage of women. So that's what's...
Well, the trouble is it is to the particular disadvantage of women, but only because women are recruited at the beginning, which I thought was the complete answer in Naeem, but I was told I was wrong. I was told you can use that not by you. Well, I'll come back.
Maybe I should have done that.
That all comes in at the justification stage. You can say, well, this is only the result of a laudable attempt to recruit more women, and therefore it's justified as long as the scales aren't absurdly long.
Well, I'm not attempting to re-argue Naeem in the Court of Appeal, or say that, well, on particular disadvantage, it's a complete defence for us to say, well, we've been very good and we've stepped up our recruitment of women. That's not...
No, I know you weren't. No, I wasn't really... I was taking another point from Naeem. What worries me about Naeem I think the trend of your argument was the system doesn't discriminate against women. I was saying, yes, it does, if it produces this effect, but only because you are recruiting more women. And it may seem very unfair that then that creates a problem for you. And the Supreme Court recognised that in Naeem, but said the answer is to justify it, not the answer is to say, well, it isn't indirectly discriminatory.
Yeah.
You can tell I'm thinking aloud, but I hope I'm thinking aloud in a way which shows you where you can persuade me.
Well, at the moment, I'm anxious to, as it were, separate out 2 points. One is the point of principle at the heart of the appeal, that Mr. Cooper is submitting that as a matter of law, the only right approach in this type of case is a distribution analysis. And that's obviously the point of principle, and that linked to that, subground number 1, that you have to look at what he's calling the variable pay, i.e. the pay above the minimum. That's the point of principle. In that type of case, which as I pointed out is a lot of cases, given that it's essentially a complaint about annual pay increases, is it right that as a matter of principle the only way to deal with it is the distribution analysis? Or is it, as we submit, necessary to demonstrate that the average pay of women as a result of the system is lower than the average pay of men? That's the question of principle. And then, of course, there's a second question, which is the result in this case, this particular case, based on the evidence of this particular case.
Yeah, and your second point does, I mean, these point not taken arguments are always slightly unattractive. I'm not even sure it's entirely fair to Mr. Cooper. He starts with the distribution analysis. That's certainly clear for everybody seeing where he put the weight of his case. But because the crude version of the average analysis means he loses because he doesn't hit 5%. But it does seem to me that he said in response to you saying, you advanced your case, well, look, the average thing actually helps me, not you. And that is something he's entitled to say, isn't he?
Well,
It supports his case.
Look, the way we understood the case was that if you based it simply on the average, then he could not win. If he thought that he could win, then obviously he didn't need to submit that the only right approach is the distribution approach.
No, because the problem with putting it simply on the average is there was a risk that people would say, look at the guidance, it's 3%, it should be 5%. But I think that is a little bit how you were putting it below, wasn't it? You accepted 3% and you said 1 to 3%. You said, well, you certainly said there may be other factors at work here, not just length of service, but you also said, anyway, it's too small, and it's all a matter for the judge how small it is.
What we were saying was that on the evidence, the tribunal should not infer, the evidence being on the evidence of the average rates of pay of the women as compared to the average rates of pay of the men, the tribunal could not infer that the system of annual pay awards particularly disadvantaged women. Because there was a question as to, well, what influence, if any, was that having? Were there countervailing influences on pay, and so on?
So that you can criticise the particulars of the evidence, and you do. But during the course of this morning, and no doubt in the EAT, Mr. Cooper was astute to analyse or reanalyse his submissions in this context. It's not just the only method is distribution. It is evidence that relates to an increased frequency or likelihood of disadvantage of the relevant evidence for the tribunal. That's not necessarily an exclusive description.
Well, on the question of increased frequency, that's my point about the average. That the average does address that question, because the average considers the possibility, because you're not just looking at obviously the frequency of lower pay, you've also got to take into account cases where the women are paid higher pay in order to assess whether there's a particular disadvantage to the group. And what averaging does is ask the question, well, here's the frequency of people below, let's say, the 50th percentile. Here's the frequency of women above the 50th percentile. Is it the case that the pay above the 50th percentile cancels out the lower pay below the 50th
It's a
percentile?
blunt instrument, isn't it, in the sense that it analyses advantage and disadvantage together. If you're looking at whether there's an increased frequency of disadvantage, that is a subset of the blunt instrument. And insofar as they're able, the claimants have sought to find a way of evidencing that particular and important subset.
Well, our submission, you can't simply focus on the parts of the distribution which show women in the lower quartiles. You also have to focus on the distribution in the higher quartiles. And our point is that without knowing what differences in pay that distribution reflects, you can't in our submission reach a firm conclusion as to whether the women as a group are paid less as a result of the system of annual pay increases than the men.
One more question before I let you go on. I just want to be clear about this. If the facts are pure in the sense that there are no other factors operating, but you have a substantial disproportional recruitment over a set period, and as a result of that, because there are no other factors in play, that has the necessary logical result of producing lower average pay over that period, but only by 2% on average over the period. Would you say that in those circumstances the judge should find that women were put at a particular disadvantage, shouldn't find that they were put at a particular disadvantage, or that it was all a question of fact for the employment tribunal to make a judgment about?
The third, and it would have been open to Mr. Cooper to seek to persuade Mr. Snelson that the pattern that was seen in relation to average pay was indicative of the system of annual pay increases having an adverse effect on women in particular. And it would have been for Mr. Snelson to make an assessment of the materials and reach a finding of fact.
And in making that assessment, it's all very well, I just think we do too much of this, saying, oh, we leave it all up to the judge. It's a question of fact. But it's a disciplined question of fact on which he's got to be looking at particular questions to reach his conclusion. And what factors could make it legitimate for him to say both, on the one hand, for two conscientious judges, to reach different conclusions on in the facts I put to you?
On the what you're calling the pure set of facts.
Yes.
The reason I'm hesitating about that is because, as I've sought to point out, what my lord is obviously asking me about a difference in average pay.
Yeah.
But there was the central issue was whether that difference was being caused by the factor that was being challenged, namely the system of annual pay increases. And so, as per Enderby, and at some point we'll look at the authorities, as in Enderby, what the tribunal has to do is look at the extent of the pay differential and look at the other evidence in the case and see whether it should infer that the impugned factor is causing the pay differential. But when I say pay differential, I mean...
I know why you don't, but that's deliberately why I gave you the pure set of facts, and I'm absolutely leaving it open to you to say, I'm an interesting concept at this stage. Absolutely open to you to say, yes, but the facts aren't pure. There is an element the judge has to make about causation. But I'm putting to you a pure set of facts where the only variable in the situation is that the women were recruited at a differential rate at the starting point of the period. And I suppose what I'm trying to tease out of you is whether it's legitimate for the judge to say 1% or 2% is too small to matter.
Well, the way that I'd answer, I hope answering the question, but the way that I'd answer is that if it's clear on the facts that what is causing a persistent 1.5% pay differential is a particular feature of the pay system here, annual pay increases.
Yeah.
Then it isn't open to an employer to say, well, that isn't a sufficiently large pay differential to matter. That's what Ches says.
Yeah. So then it is a matter for a judge. One judge might say 1.5% is enough, another might say it isn't, and I need to see at least 2%.
Well,
or you might say, can't do better than the Commission, and I'm looking for 5%.
Well, I'm not sure. I'm actually going further than that in Mr. Cooper's favour. What I've said is that if it's clear on the facts that the impugned criterion is causing a persistent differential, which is adverse to women, it isn't open to any employment judge to say, well, I know it does. Of course,
I think
but actually it's only 1.5%. That's what Ches says. But the question in this case was, what is this causing, and does it particularly disadvantage women? So hence you had to look at, well, what is the position in terms of the pay differential, and has it been established that that's caused by the system of annual pay increases?
Now I'm with you. So, but I think what's come out of this usefully for me, though probably for no one else, is that really what you're not taking the conceptual point I thought you might be taking. You're simply saying this is a messy situation with other factors in play, and that the judge must be the judge of whether it's been proved that this factor made a real difference. And he certainly couldn't do it just on the distribution analysis.
The judge, in the end, the judge must adjudicate whether this is a significant result. That is to say, one which shows that it is indeed, this factor is indeed disadvantaging women.
Yeah.
And so that's why I put it in terms of a persistent 1.5 or 2% difference. If there were a case where in one year that happened, or a case of some years it happened, other cases it didn't, then judges might say, well, I'm not satisfied that the particular disadvantage has been established, let alone that it's a particular disadvantage to women. But I accept on the authority of chairs that I can't say, well, yes, of course, it causes lower pay for women, but it doesn't. It's not much lower, or something. Arguments along those lines. Subject to de minimis, as my learned friend Mr. Cooper said.
Thank you. Well, I found that right.
Well, I'm sorry. Well, you can see my typed notes, but right. Let's go back to. May I just, as it were, work out where I've already covered the ground?
Yes.
That doesn't entail a pause. The first thing I was going to say was to deal with the facts, which I've done. The second was to make general observations about the main issue, which I've done. What happens under that heading? Well, what was I proposing to say under that heading? Well, firstly, the point that I've made, that the argument that the distribution analysis is the only right way to make an assessment of particular disadvantages far-reaching for the reasons that I've given. Secondly, though I accept this begs the question in relation to the principal ground and subground 1, in my submission it is a surprising contention that distribution is the only right way of testing the question, for reasons which I'll develop in more detail probably tomorrow morning. But at this stage, because as I pointed out, it does not involve asking, yes, but what is the average pay of the women as compared to the average pay of the men. It does potentially involve situations where, although, as in the present case, although it is said that the distribution analysis establishes particular disadvantage, it is at the same time conceded that the averaging analysis does not produce that result. I'll need to think further about Mr. Cooper's challenge about how far this point takes you, but in my submission it must mean that you could be in a case where the distribution analysis looked at least acceptable, as if it didn't disadvantage or particularly disadvantage women, but nevertheless, if you tested the average pay of the men was indeed significantly higher than the average pay of the women in the grade.
I'm not going to press you if you want more time to think about it, but at the moment, like Mr. Cooper, I can't imagine a conceptual situation in which that would be the case.
But that's my point about if you divide it according to quartiles, and actually the position is that the women are all at the maximum, the men are all on the 76th, and then in the bottom 25%, the women are all on 25%, the men are at the minimum.
I'm not enough of a mathematician.
No, that's what I'm not. I wouldn't.
Well, I mean, it should. Can you?
I
know Mr. Moretto is longing for something to do tonight. Can't you produce a simplified example that shows whether that is arithmetically possible? I've got a feeling the best you can do is get a zero result, that you couldn't in those circumstances get the result you're hypothesising. But it's only a hunch.
Point taken. But at the moment, I'm adopting a more cautious approach as always, which is simply to say that on the distribution analysis, you might look at the distribution analysis. You might think, well, it doesn't really show a marked. Okay, so there's a slight tendency for the men to be higher up, but it's not particularly marked. And you might then say, well, okay, so the claim fails on the basis of the distribution analysis, because it hasn't been proven by the claimants that they're placed at a particular disadvantage on the basis of that analysis.
Well, when you say a distribution analysis, you're talking about distribution analysis by quartile.
Yes, exactly.
And to some extent by decile.
That's right. But then you average the pay and you discover actually, no, year on year,
yeah, I got it.
The men's pay on average is higher, but according to Mr. Cooper's argument, that's neither here nor there, because you're only interested in the distribution analysis.
I mean, a graph is the distribution analysis in a sense.
But that goes back to my point that all that a graph does is show you visually where the
average is,
where the pay appears to be.
Yes.
An average actually calculates whether pay above a line neutralises pay below a line for a particular
Yes.
one group or the
What
other.
a statistician would probably say, presented with that graph, is okay. I'll show you where the average is. I'll feed all these figures in, or where the mean is.
I'll test by various complex methods whether this is a significant result. In other words, a result which does indeed show that there is a significant connection between distribution and gender. So that was what, under the heading general observations, both far-reaching and surprising. Those are the points that I sought to make as I developed earlier. Next point again I've touched on, which was to make the point that it's common ground between us, that the burden was on the claimants to prove particular disadvantage. And therefore, ultimately, the question in this case is whether the tribunal was entitled to reject a case based on the distribution analysis. It's also relevant to make that point because of subground 3, Mr. Cooper is running a point that if averaging is to be adopted, then you only look at the average pay above the minimum in the grade. We say that isn't, we don't agree with that for reasons that I'll come to, but we also say
that's a little bit difficult to reconcile with the concession that I ground out of you about only 1% being, in a pure case, 1% would be enough. Isn't that really what this point is about?
Well, not really.
Maybe not. Okay.
This is subground 3, where Mr. Cooper is saying, well, in the alternative, if averaging is the right approach, we win because the right averages to look at are the average is to compare average pay above the minimum and to look at the percentage differential.
That is why it's so small.
Well, that's part of the explanation why it's so small, yes. Other parts of the explanation are the other variables that determine pay. But what I'm going to submit is that, as a matter of construction of the statute and case law and dare I say it, logic, a whole term comparison is required at every stage of the equal pay analysis.
Now, let's just see where we're if you had a short self-contained point, I'm sure we would hear it, but would you rather, we have got to finish by the middle of tomorrow, by lunchtime tomorrow, and obviously Mr. Cooper needs a bit of time for reply.
Yep.
But, so, I mean, I'm not saying stop now if you can use the time, but you might prefer to regroup.
It's a very kind offer. Certainly, the section I'm about to come to is the Equality Act, and then to look at some of the case law, and that's not a short section.
No. It might make more sense. I mean,
that's
are you worried about? Let me just have a word, my lords.
Certainly do after lunch. Probably can do 10:15. Either or both.
Right. Well, we were just thinking. This is listed for a day and a half, and we wanted to finish in a day and a half.
Yes.
As it happens, we do not have any thing that would stop us sitting a bit early tomorrow, or if we really had to, sitting before lunch, going on after lunch. It's not intended as a encouragement. I think we might say we'll sit at 10:15, and that'll at least mean we can be excused for sitting on to 4:30. I think we'll be sharper tomorrow, and you'll have had the chance to regroup. I actually think we've been over the points very densely in the last half hour, and I'd be surprised if you weren't able to finish in time to leave Mr. Cooper a lot of time for reply.
Well, I'll be surprised too. I'm sure that the reference to being dense wasn't a reference to me. But I know exactly what you mean. I agree that we covered a number of the fundamental points.
Yeah.
We need to look at the statute and some of the
Yes,
cases.
of course we do, yes. Okay, well, let's say 10:15 tomorrow. The list has already come out, and we'll say 10:30, but ignore that. 10:15. Thank you.